Mr. Buxton.
Thank you, Your Honor. Please, court, counsel. Ladies and gentlemen, I don't start my closing argument by telling you good morning, because it's never a good morning when the state of Florida has to stand in front of a jury and ask that jury to recommend a sentence of death on a fellow citizen for a crime he committed. But that's exactly what I'm going to be asking you to do. Sometimes people are required to make hard choices, and though the choice is hard, it is the correct one. And that decision and that choice should be made based on the facts and law of the case and the circumstances surrounding the case. The facts and law are what dictate justice. It is those things that make our justice system work, and that's what makes the justice system uniform and not the product of one person's whim or emotion. But rather, justice is the product of a careful analysis of facts and circumstances and how those facts and circumstances fit into the laws that we have all agreed to live by. You heard some people in jury selection say, look, I don't care what the evidence says. Me personally, I cannot vote for the death penalty. And that's okay. I respect those people's honesty and their integrity, because if they hid that information from the parties, this system would not have been fair. This trial would not have been fair. Each of you swore that if you felt the aggravating factors outweighed the mitigating circumstances and you felt that that penalty was appropriate, that you could in fact vote for the death penalty. We are asking you as the state of Florida to do just that, because the facts and the circumstances and the law support the death penalty as the appropriate sentence in this case. The easiest decision might be to go back to the deliberation room after we're all done and say, look, let's just give this guy life and go home. But ask yourself, is that justice based on the facts and circumstances of this case? Is that justice based on what the defendant did to Theresa Green? Is that justice considering that the defendant has already been convicted of another first-degree premeditated murder? As I said, sometimes the right decision is not the easy one. The instructions that the judge is going to read to you in a few minutes, and you've heard very similar instructions when we were doing jury selection, but they're going to give you a detailed process that allows you to go step by step using the evidence, reason, and logic to reach your conclusion. I expect the defense will tell you this several times, and while it is true that your decision as to the proper sentence in this case is an individual determination by each of you, I don't want anybody to think that that means you're not supposed to go back to the deliberation room and actually deliberate. The law requires you to talk and deliberate and discuss the evidence with each other. Our jury system is so wonderful because we bring people from different backgrounds, different upbringings, different lives, different things that you've experienced throughout your life, and we put you together to talk about and resolve important matters. And it is that discussion and that exchange of ideas and opinions and interpretations of the evidence that makes the ultimate decision well-reasoned and well-informed. It's the willingness to listen with an open mind to other people's opinions and interpretations of things that you may not have thought of that makes the decision well-reasoned and well-informed. So I ask that when you go back to the deliberation room, that you discuss the facts and circumstances of the case. Discuss the aggravating factors that you've heard and the mitigating circumstances. Talk about it amongst yourselves. And after each person has had a chance to discuss their opinions and tell each other what you think, only then take a vote and start marking up the verdict forms. That process is what makes the ultimate decision in this case well-reasoned and fully informed. I want to talk to you a little bit about the mitigation that's been presented to you over the past couple of days. And much of that testimony is about the defendant's background, his upbringing when he was a young man. Anytime somebody commits a crime or multiple crimes, it not only affects the defendant and the defendant's family, the victim's family, but also those people who knew the defendant. And these witnesses presented by the defense have come in not because of their choice, because of that man's choices. listening to their testimony over the past several days, it sometimes may become easy to put in the back burner or forget about what really brings us here, and that is the murder, the heinous, atrocious, cruel murder that this man committed on Theresa Green. And that's why we're here. I ask each of you in jury selection to promise me that you would and could meaningfully consider any and all mitigating evidence presented to you, and you all said you would. And I ask you to do that. I ask you again to go back, discuss the mitigation, talk about it, reflect on it, meaningfully consider it. But I submit to you that when you do that, the mitigating evidence that has been presented to you deserves no weight. The defense's mitigation consists primarily of friends and family members of the defendant, some who have had really no contact or limited contact with the defendant for over 40 years, coming in and telling you when they knew him, the person they knew years ago, he was a good guy. Those people seem like very nice people. There's no question about that. I mean, you heard from Sherman Alexander this morning, 3 foster kids, 2 of his own children. He's doing well in life. And some of those witnesses, especially the Longs yesterday, it was difficult to listen because they became teary-eyed. They became upset because their loved one, no one wants to see their loved one in this position. But again, they are not here because of your choice or their choice. They're here because of Mr. Hunter's choices. Not only his decision to murder Theresa Green, but his decisions that he's made throughout his life to hurt other people as well. Some people that you heard, some of the mitigation witnesses you heard, knew him 40 years ago and had limited conversations with him, limited interactions, if any interaction. When he was over at the Alexander's house as a kid, you heard that he was respectful. He acted right. He followed the rules. So we know he can follow the rules. He can be respectful. He can do what people do if he chooses to do so. Sherman Alexander was raised in the same neighborhood as the defendant. Sherman Alexander has no felony convictions. Sherman Alexander hasn't killed 3 people. Sherman Alexander was raised in a similar household. He said, look, his parents, the defendant's parents, were similar to my parents. Sherman Alexander still supports his friend. He is a true friend, and regardless of what the defendant has done in his past and done in this case, Sherman Alexander still supports him like a friend probably should. Some people said the defendant, when he was young, was nice, was funny, was respectful. I submit to you, ladies and gentlemen, being nice does not mean that a life sentence is appropriate. Being nice when he was a teenager to an elder does not mean that a life sentence is appropriate in this case. I believe one of the Longs said yesterday that he took care of his daughter, that she watched the child when the defendant went and got Pampers. Well, ladies and gentlemen, I submit to you, that's what a parent does. That's what every parent should do and is legally obligated to do. Because the defendant did what a parent should do for his own child does not mean a life sentence in this case is appropriate. It is interesting that I don't think any witness knew about the defendant's prior violent criminal history. They may have known he was in prison and he did something bad, but none of them knew any of the details. The person they may have known 40 years ago is clearly not the man that this man has become. They clearly did not know the true side of the defendant, the violent side, the side that time and time and time again chose to hurt people. They knew the person that the defendant chose to show them. They knew the person that the defendant was as a child. Alfred Costa testified yesterday that the defendant came and lived with him in Houston, lived with his house, and then he moved into Alfred Costa's grandmother's house. Mr. Costa didn't know that the reason he went to Houston was because he was fleeing because he murdered Aurora Huntley in California and then murdered Theresa Green here in Orlando. Mr. Costa did not know that the defendant was a fugitive of justice from 2 murders. The witness's knowledge and impressions of the defendant are at best incomplete. Ask yourself, how much weight do you give their testimony and their opinions and their impressions of the defendant, especially when they're based on their impressions, really about 40 years ago, especially when their opinions and their impressions are based on half the story, not the story of the defendant's criminal acts. Simply because there are some people in the defendant's life who, again, based on decade-old impressions, say they love him, does not mean that the death penalty is not warranted in this case. Everyone can find somebody in their past to come in and say, when I knew him, he was a great guy, I love him. That doesn't mean the death penalty is not the appropriate punishment here. The witnesses that have testified didn't know the details of his prior crimes. They didn't know the details about how he killed 2 people before killing Theresa Green and how he hurt 3 others by shooting them. They didn't know about the pain that he has caused other families because of his choices and his decisions. If they did, you think they would have said the same thing about the defendant. You think their impressions may be different. There's no doubt the defendant has people who love him, but it is also clear that the defendant's history of choices that he has made not only hurt his own family members, but also the friends and family members of the people that he has hurt, like the Butlers, like Octavius Hayes, the son of Theresa Green. I stress in jury selection, please go back and consider this mitigation. Please do. After you do it, I submit to you that the mitigation presented by the defense and the opinions of these friends and family members, many of whom are really uninformed about the defendant's true character, should be given no weight at all. I want to shift gears and talk about the aggravating factors that the state has presented. Like we talked about in jury selection, and like the judge will read you, aggravating factors are factors that increase the gravity of the crime or the harm to the victim. They are factors that make this first-degree murder of Theresa Green more egregious than other first-degree murders. The state only has to prove one aggravating factor beyond a reasonable doubt for the death penalty to be an appropriate sentence. Here the state has presented 2. Your first decision is going to be to determine if the state has proven those aggravating factors to you beyond a reasonable doubt. If you find that the state has proven an aggravating factor, that factor then goes on your weighing scales to determine what the proper punishment should be. First aggravating factor the state has presented to you is that the murder of Theresa Green was especially heinous, atrocious, or cruel. And this addresses from the victim's perspective, from Theresa Green's perspective. And notice the word or. Mr. Nunley told you in an opening statement that it is not and. The state doesn't have to prove that the murder was especially heinous, atrocious, and cruel. It's or. So if the state has proven any of those 3 modifiers, then that has been proven. I submit to you the evidence in this case has proven all 3. This aggravating factor, again, focuses on the victim's perspective and how she was feeling, the pain and suffering that she endured before she eventually died. The judge will tell you that heinous means extremely wicked or shockingly wicked. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless, pitiless, and was unnecessarily torturous to Theresa Green. For this aggravating factor to apply, the state has to prove that the victim, at the time that she was being killed, was conscious. Because if she was unconscious, she would not be aware of what was happening to her. She wouldn't be experiencing any kind of pain and suffering because she's unconscious. So what evidence do we have to show that Ms. Green was, in fact, conscious at the time the defendant was murdering her, was strangling her? Obviously, and I expect the defense may point this out, there was no witness who came in here and said, look, I was there, I saw the defendant strangling her, and the victim was aware he was conscious. Why? Because people don't strangle other people in front of witnesses. That's why you have to look at the facts and look at the circumstances about, as far as the case, and the circumstances surrounding how this murder occurred. So how do we know she was conscious at the time she was being strangled? Well, we know from both medical examiners, both Dr. Arden and Dr. Utz. Remember, Dr. Arden was the defense, the medical examiner the defense called. Dr. Utz was the medical examiner the state called. Both of them said that in their review of the autopsy documents and records, they saw no evidence whatsoever of any kind of a skull fracture, no evidence of brain trauma, a brain bleed, anything like that. Nothing to indicate or to suggest or that would cause her to fall into unconsciousness like you would if you fractured your skull. The autopsy would have shown that, and there was no evidence of that. So there's no indication or no reason to think that she was not conscious. Her blood alcohol level was about a 0.28. Again, we know from the testimony of the medical examiners that that number is likely artificially inflated. Why? Because she was undergoing decomposition. And during the decomposition process, we know that the bacteria in the body cause fermentation and cause alcohol to be produced. How much? We don't know. That is undetermined. But witnesses said she was impaired. But keep in mind, ladies and gentlemen, when her and the defendant tumbled down those stairs that night in that hallway, testimony of 3 witnesses, Joseph Butler, Joyce Butler, and Lisa Moore, all told you when she got to the bottom of the stairs, she stood up and she walked up that flight of stairs, step by step. No one had said that they had to carry her, or she was so impaired or so out of it they had to pick her up and drag her up the stairs. She walked up there on her own. So ask yourself, how truly impaired was she? And I submit to you that even if she was impaired, when the defendant has his hands wrapped around her neck, that fear, that adrenaline is going to take over. That basic animal instinct of flight or fight is going to take over. She's going to be fully aware of what happened. We also presented to you some physical evidence to show that she was conscious when she walked into that apartment with Demorris Hunter. You heard about the watch that was found. The watch with the defendant's DNA. It was found on the ground, and Octavius Hayes picked it up and put it in the bathroom counter. But you heard that watch was broken. If she would have walked into that apartment, fallen onto the bed, into unconsciousness, why would that watch be broken? We know that the band wasn't broken when she fell down the stairs because it was still on her wrist and it ended up being in her apartment. No one said they saw her pick up this broken watch, broken inside the house. That is indicative of a struggle. That is indicative of Ms. Green being conscious and being aware during a struggle. We also have evidence of that hole in the wall that Octavius said wasn't there earlier. Again, that is evidence of a confrontation or an altercation inside that apartment after they entered that apartment. If she would have walked into that apartment, fell onto the mattress, fell into unconsciousness, why do we have a hole in the wall? The hole in the wall is because there was an altercation, which shows she was aware and conscious. There could be an argument, maybe she walked in there and she was so drunk she fell into the wall and caused that hole to happen. Well, if that were the case, and that's all that we have, don't you think the defendant would have maybe called 911 or called for help if she was that bad off and fell into the wall? We know that didn't happen. And to believe that happened, you'd have to ignore all of the evidence of the strangulation, the hemorrhage, and the highway bill that we've all heard so much about. The evidence on her neck. Which brings me to the physical evidence on her body. The injuries to her neck show that she was conscious during the strangulation process. She was conscious when the defendant had his hands wrapped around her neck and was squeezing the life out of her. Dr. Utz, and the defense I'm sure will point this out to you as well, Dr. Utz said, look, I can't tell you with any possible doubt whatsoever that those are fingernail marks, but they sure look like fingernail marks to me. And you have to, again, look at the facts and the circumstances surrounding this case to determine what causes those marks. When you do that, the only reasonable interpretation is these marks were caused by fingernails. Look where they are. They're in the exact place where they would be on her neck if he has his hands around her neck, squeezing. Can we tell you, can Dr. Utz tell you, are those fingernail marks from the defendant or from the victim? We don't know. But in either scenario, the presence of those marks and how they appear show that she was conscious and she was aware of what was happening when she was being strangled by that man. They're not just 4 marks in a row, 4 simple marks. If she was unconscious and the defendant decided to then strangle her to death, she's not. If she's conscious, she's not resisting. If she's unconscious, you squeeze, you hold, you squeeze until she's dead. Here, we see chaotic pattern of marks. We see multiple marks in different locations. What does that indicate? It indicates that he is squeezing and releasing and squeezing and releasing and moving his grip around to cause these additional marks. Why? Because she's conscious, because she's aware, and because she's fighting and struggling and thrashing. If they're from the defendant's fingernails, that is why there are so many different marks in different locations, because he's repositioning as she's struggling and squeezing out. If these marks are from the victim's fingernails, well, we clearly then, it's obvious that she would be aware and conscious, because what she would be doing is reaching around her neck, trying to fit her fingers between his hands and his fingers around in her neck, to try to pull his hands off of her neck, to try to stop the strangulation from happening. And in that process, she is causing those marks on her own neck. And you saw they're on both sides. She's trying her best to pull his hands away from her neck over and over again until she is no longer able. That's why there are multiple sets of marks like that. So regardless of whether these marks are caused by the defendant's nails or the victim's nails, both scenarios show that the victim, Ms. Green, was aware, was conscious, and was fighting. Fighting to survive. Because we know she was fighting to survive and struggling, we know she was aware, we know she was conscious, we know she was understanding what was happening to her. She was aware that the defendant, her boyfriend, is somebody she supposedly cared about, was wrapping his fingers around her neck, around her throat, and squeezing. That fear would have been unbearable. Second by second, minute by minute, she's looking straight at the face, straight in the eyes of that man as he's putting that pressure and squeezing the life out of him. Eventually, she would start to drift in and out of consciousness, and she would still fight and thrash and struggle. And as she would loosen, the defendant would loosen his grip because she's struggling and fighting. That blood would go back into her brain to cause her to remain conscious and remain aware. Common sense tells you during that process, she would have panicked. As she struggles and manages to loosen his grip, a terror would be starting to set in, and eventually she is going to realize that she is going to die. She struggles until she can't struggle anymore. She can no longer thrash, she can no longer fight. Only then does she thankfully drift into unconsciousness. Only then does her awareness of this horror end. Only then does her pain and does her suffering and does her sheer terror stop. And as the defendant continues to strangle her, only then does she die. Ms. Green wasn't shot in the head. Ms. Green didn't have an immediate death or an instantaneous death. Her pain and her suffering, her mental anguish and her terror was prolonged and it was drawn out. There is no doubt, ladies and gentlemen, that this murder was conscienceless and pitiless. There is no doubt that this murder was unnecessarily torturous to Theresa Green. This murder was heinous, atrocious, and cruel under any set of definitions. Why does this aggravator deserve great weight? Because this aggravator goes to the sanctity of life itself. No human being should have to endure the suffering that Theresa Green did at the hands of that man. This aggravating factor alone outweighs any mitigation that is presented to you. But the state has presented more. The state has also presented a second aggravating factor. That the defendant was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. Why is this aggravating factor so weak? First, it shows that the murder of Theresa Green was not an isolated incident. Sometimes people act harshly. Sometimes people use bad judgment, make bad decisions. Sometimes people do things as a result of an isolated incident. When a person has prior convictions for violent crimes, that's not the case. When a person has convictions for felonies that involve the use or threat of violence to another, for felonies that inflict both physical and mental harm upon other people, it becomes obvious that violence is in that person's nature. That's the case with the defendant. Violence is part of who he is. He's demonstrated that for a long time. He's demonstrated that since about 1985, at least, when he was 19 years old. That violence has progressed, as shown by the different convictions that he has acquired over the years, and how the severity of those crimes that he has committed has gotten worse and worse. You heard from Assistant District Attorney John Brillhart. You also saw some documents introduced by the state showing the records and the documents of his prior criminal convictions, all from the ones in 1985, as well as the one in 2002, for which John Brillhart was the actual trial lawyer that prosecuted the defendant, where he was found guilty of first-degree premeditated murder. The violent crimes that the defendant has committed in his life were not committed all in one day against one person. This is not a situation where he had a one-time lapse of judgment and racked up a bunch of felony convictions in one fell swoop. His violent crimes were committed mostly on different days, in different ways, in different events, and on different victims. You heard from John Brillhart, who explained the documents proving the prior convictions, and they are in evidence. I know they're relatively small, that they are probably difficult to see, but they are in evidence. And he explained to you the nature of his prior convictions, both from 1985 and regarding the first-degree murder of Laura Huntley that happened in 2002. He explained to you the unique PFN, or personal file number, to make sure that we know that these convictions all relate to that man. And Mr. Brillhart, remember, also identified the defendant as the person that he prosecuted for the 2002 murder of Laura Huntley. You also heard from a fingerprint analyst from Orlando Police Department who compared his known prints, the defendant's known prints, to the fingerprints taken of the person who was arrested in California when he was brought back in 2003. They're the same person. So there's no question, I don't expect there to be any dispute, that all these prior convictions that have been introduced are the result of his actions, this defendant's actions. The defendant's decision and choice to begin committing violent crimes began around 1985. And you heard that on January 6th of 1985, the defendant was convicted, this is when the offense happened, but he was later convicted of voluntary manslaughter with a firearm on victim Cesar Guzman. In that same event, on that same day, he was convicted of assault with a firearm with victim Jorge Hernandez because he pointed the gun at Jorge Hernandez with the apparent immediate ability to carry out that threat. Moving on to the next month, in February 4th of 1985, the defendant shot Adolphus Williams with a sawed-off shotgun, and he was eventually convicted of attempted first-degree murder with a firearm causing great bodily harm. 10 days later is when the defendant then shot Eric Wright. He was convicted of attempted first-degree murder with a firearm, again, causing great bodily harm to Eric Wright. And then, March 29th of 2002, the defendant shot and killed Aurora Huntley. He was convicted of first-degree premeditated murder, just like the murder of Theresa Green. After he commits the crime against Aurora Huntley and murders her, he then flees to Orlando, where he makes contact with Theresa Green and starts up a relationship with her. And now we know why the defendant was using a fake name when he was here. We know why he was going by Mike, because he was running from the police in California because he killed Aurora Huntley there. Less than 2 months after murdering Aurora Huntley, he comes to Orlando and murders Theresa Green. He then flees to Houston, where he is arrested, and then he is brought to California to answer for the charges regarding Demorris Hunter. He is convicted of first-degree premeditated murder there. Then he is brought here to Orlando, Florida, to face the charges that we have here. The defendant has been convicted of not one, not two, but 5 prior felonies. And ultimately, the defendant has killed 3 people and tried to kill 2 others by shooting. When you consider whether the defendant deserves life in prison, when you consider if he deserves leniency or mercy, consider his lifetime of violent criminal behavior in the people that he has hurt and killed. This aggravating factor deserves great weight, and it alone also vastly outweighs any mitigating circumstances that have been presented to you. I submit to you, ladies and gentlemen, when you place the mitigating evidence that is presented to you on a scale, and then you place the aggravating factors on that scale, your scale should tilt far towards the death penalty, because the aggravating factors vastly outweigh any mitigating evidence presented to you. Once you make that determination that the aggravating factors, in fact, do outweigh the mitigating circumstances, the next step in your process, according to the instructions the judge is going to read to you, is to determine what is the proper punishment. I expect the defense will tell you several times that the law never compels or requires you to vote for the death penalty. I told you that in jury selection, that's a given. But what you do know is there are about 9 pages of instructions that you either have been given or are going to be given, and the judge is going to read to you, that will walk you through and guide your decision-making process. After listening to the evidence and determining that there are very weighty and sufficient aggravating factors, and those aggravating factors outweigh the mitigating circumstances, that logical and reasoned moral judgment should be that a life sentence is not warranted in this case. This is an emotional decision, ladies and gentlemen, but I submit to you that the law is most fair, the process is most fair, and the integrity of the judicial system is most fair when your decision is reached based on reason, logic, and a logical method applied in your decision-making process. This decision is a very difficult one, ladies and gentlemen, and it should be. But as I said earlier, sometimes the hard decision is the right one. Each of you in jury selection swore that if you felt the aggravating factors outweighed the mitigating circumstances, and you felt the death penalty was appropriate, that you could vote for it. But remember, ladies and gentlemen, the ultimate responsibility in this case sits right there with Mr. Hunter. He is responsible for the choices that he has made in his life. He is responsible for his decision to strangle Theresa Green to death. He is responsible for the decision to commit murder, and he is responsible for causing pain and suffering and death to people in his past. He's responsible for where he sits right now. How many families does the defendant have to destroy before the death penalty is appropriate? How much pain and suffering does the defendant have to cause before the death penalty is appropriate? How many people does he have to kill before we say, enough is enough? Thank you.